Hello, everyone. Stephen Hale back for the COM 401 argumentation and debate class. I'm here discussing my claim that I wrote in week one. My original claim was based on the idea that there are people who are uneducated on the Second Amendment. A lot of proud gun owners out there who, love their right to carry a weapon, but they don't fully understand what that right means. And as a result of that, they're fighting the wrong battle. They're fighting a battle that, against a government who's going to take their guns and, you can't make me turn in my weapons. That's not the right battle. And I think it comes from our people being uneducated on what the Second Amendment is and what it means. So I just wanted to go over a few ideas from what our founding fathers wanted and how they viewed the Second Amendment and then where it's translated to today. A lot of this information I got by just contacting the National Rifle Association, getting a lot of information from their websites, went down to the library, looked through a couple of books. But most important, I think we'll start with how the Second Amendment reads, and that is a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that being said, you already have the right. This is not about you having the right. The right already exists. The Second Amendment is your right for the government not to infringe on that right. So if you're already fighting, the government can't take my guns, well, of course they can't. You don't need to say that because they can't do that according to the Constitution. The Second Amendment is your right to protect that right. And this goes all the way back to James Madison when they were constructing the Bill of Rights. There were several ratifying conventions that took place when they ratified the Constitution. And out of all those that were done, there were 5 conventions where they discussed the right to bear arms and what that meant. And to put that in perspective, everyone loves the freedom of speech to say what you want to say. There were 5 conventions for adding a firearm amendment to the Constitution or a right to bear arms. And there are only three mentioned for freedom of speech. So our founding fathers, this was a big deal to them. And even Thomas Jefferson said, no free man shall be debarred the use of arms. So it's within your right. Well, the common question that comes up in this is the militia the National Guard? And so if that's the case, then it doesn't mean to this because it's only supporting our need for a militia. The Militia Act of 1792, though, kind of disputes that. It was adopted a year after the Second Amendment was ratified, and it said that the militia included any able-bodied adult males, anyone who was able-bodied to join the National Guard. The National Guard was not established until 1903. So you've got the Militia Act of 1792, which declared what that was. That excludes the National Guard from being considered a part of our militia. So you're safe in that. So something a little bit more recent was in June of 2008 when the Supreme Court issued a decision on the case of the District of Columbia versus Heller. It was a 5-4 decision in which they upheld the right for individuals to possess firearms, and they could use them not just as part of the militia or as part of the National Guard, but actually as an individual's right. And the court also stated that the Second Amendment is not meant to protect a state's right to maintain a National Guard or a militia. So if people try and say that the militia is the National Guard or that's a state decision, it's actually false. It's actually a federal decision by the government, and they cannot infringe on that. So it's within your right. The court ruled that the Second Amendment, the operative clause, the right of the people, was codified, and it went on to show 6 other provisions inside the Constitution that said the people, meaning us. It refers to all members of a political community, not just a subset. So there is no a subset like the National Guard or within that. Basically, to sum that up, you've got, the Second Amendment, it protects your individual right. That's what it's here. It's not to protect a group right or a collective group of people. It's for, it can be used. The decision with Heller and versus the District of Columbia, it stated that it's an individual's right to protect that firearm for legal purposes, and legal purposes would include sporting uses or individual defense. So it discounted the idea of a collective group, and it's within your rights. So that's kind of my argument to this. If you're fighting, that the government cannot take away your right to bear arms, I appreciate your zeal, but that's not the fight that gun owners like myself need. I need you to understand what the rule is on this and what the interpretation of the Second Amendment is and how that can affect you. So please educate yourself more on what the Second Amendment is, because other than that, we're just really spinning our wheels here and we're not saying anything of real value. The right is yours. It is already here because of what our forefathers did with the Constitution when they ratified it and they added the amendments. That was a establishment of the protection of your rights. So the government can't take it. You already have the right not for it to be infringed. Okay? Thanks for listening.